and they have multiple locations across the DFW areas. And the special thing is that you can actually reach him. He will give you his contact information. I don't know if you have, you know this or not. A lot of title companies, they have their lawyers, attorneys behind the scenes. You can never reach them. All you can reach is the front desk or the escrow officer. You can never reach the attorney. He is reachable. So that is special. A lot of times it saves us lives and save times. I can just text Sean or email him, you know, he will reply. That saves a lot of time. So this is Sean, and I'll now hand it over to him, and he will give us some legal updates.
Yeah, thanks, Teresa. It's probably been 10 years, huh?
Yeah, it's been 10 years. So
wow.
Let's give him a round of applause.
So is this, Jen, I don't need this one, right? Okay.
Oh, this is just for the people who have questions.
Yeah, I think so. So my name is Sean. I've been a real estate attorney 17 years. So I've owned Tiago. I started it 12 years ago. I started Tiago Title, and then I've had my own real estate and corporate law firm for 12 years. Been an attorney for 17. A lot of my practice still to this day I represent title companies. I represent real estate brokers, agents, lenders, developers, builders, you name it in my law practice, but transactional and litigation. So pretty involved in the community, the real estate community. I take it very seriously to represent and defend you guys. I've got 23 active TREC complaints right now that I do defense work on. So I do a lot of defense work. Unfortunately, in the industry, ever since we had the NAR settlement stuff come out, the real estate agents is a profession. You guys are getting attacked left and right. And I mean this with the utmost respect because I love you guys. I really do. But you guys are very easy targets. I could probably pull any one of y'all's files, even a 50-year seasoned broker, and probably find at least 20 things wrong with your file on a given day. And I don't mean that to be mean or rude. It's just that's what we're here for. And that's if I can find it, plaintiff's attorneys can find it, right? And so my goal, my passion has been for 17, bless you, for 17 years has been defending agents, you know, coming in and doing the education and saying, hey, look, these are some of the things you got to be aware of. This is how you could change this. This is the language. So Teresa's right. I mean, I am available pretty much 24 hours a day, 7 days a week. I sleep between 11 and 4. So you're probably not going to get me at that point in time, but you'll probably get me on Sunday, usually get me at 4:35 in the morning. So if you text me at 11 o'clock, I'm going to get you at 4 just to wake you up since you texted me at 11. No, I'm kidding. I won't do that. Okay. But I probably will reply. So as of September 1st, we had a lot of law changes. 3 really big important ones that I'm going to talk about today. I've been now going all over Texas talking to real estate brokers about these law changes. They're very important. And in August, I put out a little thing on my social media. I would love if you guys follow me at Sean.Clemenson. Put out weekly video. I put out daily videos actually on various legal topics. So I think it was in August I put out something about, you know, I'm so shocked that real estate agents aren't talking about Senate Bill 140 and Senate Bill 17 and House Bill 3611. And then all of a sudden it must have scared the stuff out of, and forgive me if I curse in advance, scared the crap out of people. And everyone's like, whoa, what are you talking about, Sean? And it scared me for the industry that nobody was talking about some of these law changes. And that was in August. And then the laws took effect on September 1st. And so I've been traveling every week speaking about 3 of the big law changes that I think are important for you guys. You guys have probably heard of some. So some of the stuff I'm going to tell you today is not new. As with any time the law changes, you have to keep in mind that people haven't challenged the law yet. And so a lot of times what we do as attorneys, we interpret it. And this is, you know, today is Sean's Clemenson's opinion on what the statutes say. That's my opinion, right? But we don't know what a judge is going to do. We don't know what a jury is going to do. We don't know what the attorney general is going to do in the case of Senate Bill 17. We don't know what any of them are going to do because the laws just took effect. And so when we talk about it today, you're going to hear me say multiple times the conservative approach is, right? Because the conservative approach usually 9 times out of 10 will prevent you from being sued or prevent you from being fined. And so I take the conservative approach, but keep in mind, people will challenge laws, people sue, courts interpret statutes, and then we get more case law. And then we have a better idea as to how's it interpreted, how's it being applied, what's the practical consequence or the practical consequences of it. So keep that in mind when we talk about it today. Some of the stuff, especially Senate Bill 17, we're going to talk about is a little bit sensitive. So we have to keep that in mind. How many people know what Senate Bill 17 says? Figured, yeah, it's about right. I don't want to get into the politics of the law today because I have my own opinion on it, and I'll keep that out of today. I'm not a fan of it. But Senate Bill 17 says, and it took effect as of September 1st. What Senate Bill 17 says is that if you are primarily reside in China, North Korea, Russia, or Iran, you cannot own real property in the state of Texas. Okay. What it really says is if you are deemed a country that supports terrorism, in essence, is what it says. If you are from one of those countries, even though you don't have any bad bone in your body, then you cannot buy real property in the state of Texas. And if you buy real property in the state of Texas, the consequences are harsh. Now, we are not talking about anybody from any of those 4 countries that are here on valid reasons. Government visa, student visa, work visa. We're not talking about any of those people. Those are way over here. They're exempt from Senate Bill 17. We don't have to worry about those. What we're talking about are people that primarily live in any one of those countries that happen to want to buy here. I'll give you an example. And it's come up every week, at least once or twice a week since September 1st. I get a phone call. It usually goes something like this. Sean, I've got this really great client. She lives here in Texas, lives in Plano. And her mom, who lives in China, wants to buy a property here because, the plan is to sometime move over here. Awesome. That's great. But Sean, I don't know. I heard about some law, Senate Bill 17 come out, and, I thought it said like you can't buy property here. What am I supposed to tell my client's mom that lives in China that's wanting to buy property here? Well, as a real estate agent, you do not want to violate fair housing laws. So you can't ask questions like, is your mom from China? You can't ask that. Okay, you can't say anything like that. That violates fair housing laws, federal law, right? But it's okay if you're a real estate agent and you have somebody say, well, my client's mom's in North Korea, China, Russia, Iran, whatever, and they want to buy here, or my client's dad, or my best friend, or whoever. It's okay to say things like, look, I've sat in a class with an attorney and he mentioned that there was a law that came out on September 1st that could impact your client's mom's purchase of real property here in Texas. And so I think it's really important for you, client, to have your mom and you consult with an attorney about the legal consequences of buying property here. That's a real life phone call I get at least twice a week and have since September 1st. Then we get on the phone, right? So I set a time to talk with, your client that bought a house in Plano and their mom's in China and they're wanting to buy over here. And we talk about it. And she's like, the individual that's in China is always asking the questions. Well, what happens if I brought it? Because I'm a cash buyer, I was going to pay cash. I'm not taking out a loan, which it would generally have to be a cash buyer. But I want to buy property next to my daughter because I want to be there at some point. My goal is to move there in 5 years. What happens if I buy a property in Plano? What happens? Well, the Attorney General of the state of Texas can initiate what's called a divestiture action. And a divestiture action is a legal proceeding where a judge, in favor of the Attorney General, could order the property to be sold. Okay. The penalty for buying real property in the state of Texas is $250,000 fine or 50% of the equity, whatever's greater. Now that's after payment of closing costs. That's after payment of a loan, if there is one. Chances are there's not. If the real estate commissions, liens, anything like that. So it's after payment of that, just like any other typical closing statement, right? And the call on this call, we usually the mom and with the dad, whoever I'm talking to that's from Iran or China or Russia goes, wow, geez, that's not worth it to me. Okay, I don't think it's worth it either until we have a little bit more clarity on the law. There is a group of Chinese nationals that have already challenged the constitutionality of that law, right? They've already said it violates due process, it's discriminatory, but we haven't seen how that plays out yet. And we won't see how that plays out for months, if not years. So we don't know what's going to happen. So the conservative approach, like I said, you're going to hear me say that. The conservative approach is for your client's mom that lives in China not to buy the property here. You guys are going to deal with that at some point, probably. And I bet some of you have already dealt with it. I know you have. I know somebody else at your brokerage already has because they've reached out to me about it, right? And the question, the response from you as an agent really has to be, you can't ask those questions. You can't say, is your mom from China? It has to be, and you can't give legal advice, right? Like you guys know that. You can't give legal advice. So it has to be something like, I sat through this class and this attorney mentioned, that there's a new law that took effect. I think before you do anything and make any decisions, I really encourage you. In fact, from my brokerage policy would require you to consult with an attorney to figure out what the consequences are of that action. And then if you decide that you want to buy it anyway, in violation of Texas law, not a good idea, then instruct me to do that in writing as an agent. That's Senate Bill 17. Not many people are talking about it because it's a sensitive subject, right? It's, again, right, wrong, or indifferent, it is what we have to deal with. And the laws, yeah.
Question.
Yeah.
I did some Google search and did my own research, and I kind of pull up the bill itself and kind of read it in kind of plain English. I could be totally wrong about this. That's why I want to ask you. I feel like there's a line saying that you cannot. So literally the line says this, people from these countries cannot buy any real estate properties except for primary residence.
Homestead?
Yeah, homestead.
Yeah, well, there's a carve out or an exception as a primary residence, but how are you going to prove that it's your primary residence?
So that's my question.
Right. So the exception in practice is worthless. Because how can I prove if I'm in China that I am in the United States under lawful means and therefore can prove it's my homestead? You can't, right? You can't.
Would that apply to people who actually have a visa?
No, there's an exception. Like at the start I mentioned, there are exceptions for people that are in the United States, in Texas, because this is a Texas law, under lawful means. Student visa, work visa. I think there are tourism visas that sometimes, if you're in the United States, Texas, under lawful means, this does not apply to you. Okay. I think that we're going to see some changes to that law at some point. It may not go away, but I think we're going to have to see more carve-outs, more exceptions, for some of those examples, like a mom and dad that are trying to move from China over here. Because that was done so much during not to get off track, but during the EB-5 program. We still have the EB-5 program, immigrant visa program, right? And so a lot of people would buy property in the United States in order to be able to qualify and get a visa. And so this Texas law, in a way, makes that a little bit more difficult, right? So I think we're going to see case law come out on it. If it comes up, give the response that I gave you, right? It's at this point in time, there's too much that's left to be known. In other words, there's a lot of unknown. So I don't think it's worth the risk to buy and then have the Attorney General figure it out and force you to sell it and take that big of a hit. I don't think it's worth it. But so that's Senate Bill 17. Does anybody have any questions on it?
So are they looking at like wire transfers? So what would prevent?
So yeah, that's a good question.
Wire over the season.
Yeah, that's a good question. Like, and that's the question I get is some variation of that a lot, which is like the practical. Well, how are they ever going to know, right? I'm like, You know, I don't know. I don't know if they're looking at it or not. I know as an owner of a title company that sends out a lot of wires, I know for a fact the Federal Reserve, they track wires a lot more than people think they do. So where it originates from, I don't know. You know, is the Attorney General of the state of Texas, does he have a task force to be able to go look? Probably not. I don't know. But yeah, I mean, that's like, certainly as an attorney, I get this question a lot just in general. We're like, well, Sean, I mean, you think I could try it? I'm like, look, as an attorney, I can never tell you to break the law, even if the risk is really low. But yeah, I mean, is the likelihood that the Attorney General is going to figure it out very high? Probably not. But if they do, and they ask and they figure out where it came from, and you or I gave them that advice to do it, you and I are effed, right? So the approach is always going to be, look, talk to an attorney. You can't suggest that you violate the law. Yeah.
I do have another question because these questions actually triggered another conversation we had with another title company, and they said actually there is a title company organization or something, and they actually came up to talk to the the Senate about the SB 17, saying that they're actually, as a whole, as a body of title industry, a title company, they're not responsible for anything that's a result of.
No, you're talking about probably the American Land Title Association and the Texas Land Title Association.
Okay, something like.
So those are our trade associations
Okay.
as title insurance companies. But that is the truth, right? I mean, remember, I'm here as an attorney and a title company, not just the title insurance. What I'm telling you today is more the law, less title. But yeah, for us as title companies, there's no liability for us.
Yeah, no liability.
Like nobody's ever going to pin this on a title company.
Right.
It's not our job to figure out, because people have asked me that. Well, don't you have to determine if somebody's a U.S. citizen?
No.
Fuck no. No.
Like who? Like we cannot determine.
I
that
can't
either.
go, no.
As a realtor.
That doesn't look like a valid passport. No, sir, you're not buying in Texas. No, I mean, that's not, the title companies know we have zero obligation to do that.
Right. And as a realtor, we cannot do that either. Like
No, that's what I'm saying. Like, you don't want to do it either.
I can't do it either.
No,
So
of course not.
Do it.
No, right. We back to our practical side. Probably not a lot, right? If the title companies are not tattletelling and the agents are not tattletelling, what's the likelihood that someone's going to figure it out? Probably not very high. But none of us can sit in here and tell somebody to knowingly violate a very well-established Texas law, right? So if somebody tells you, well, I want to proceed knowing the risk anyway. Okay.
But in general, a law like this, who would be the enforcing
Attorney
body?
General of the state of Texas. That's it. Attorney
That's
General.
it?
Yeah.
Okay,
It's a
he's very
Texas
busy
law.
Right
No, he's busy. It's a Texas law, and the Attorney General enforces Texas laws.
I mean, there's
nobody out there monitoring this stuff.
There's nobody monitoring.
No.
Okay.
Well, we spent a little more time talking about Senate Bill 17 than I thought, which is good. So does everybody know what House Bill 3611 says? Does anybody know about bandit signs?
I heard. Yes.
Yeah. Yeah, we'll talk about Senate Bill 140. So House Bill 3611, also came out. And House Bill 3611 is a bill that passed on September 1st that aims to, and it's not just a shot at real estate agents, it aims to clean up a lot of the signs you see in public rights of way. So we'll power wash your house, we buy houses, lawn services. I mean, whatever, you name it. Those are, any type of sign that is in a public right of way. House Bill 3611 aims to get rid of. And that's was the goal of House Bill 3611. There are exceptions to House Bill 3611, which we will talk about in 1 second. So let me get this to Kathy. I got to get my social media, y'all.
Oh, yeah.
You know what I mean?
Y'all should.
Golly, man. Kathy made me start doing this 2 years ago.
You're live online already.
Oh, am I good?
We're doing live.
Autographs come next. Okay.
Oops.
I got it. I'll pick it up.
Okay, well, you just figured it out. Good
So I
God.
did send out a message right
Jesus.
around October 1st to say that we have to be careful about our open house signs.
Yeah, so open house signs open house signs too, and this is why I've been talking about it so much. Open house signs fit squarely within is a bandit sign. And so if I go put an open house sign in a public right of way, I got to keep reinforcing that, a public right of way, then you can be fined. But we'll talk about that, what that looks like in a second. So we're talking about public rights of way. We're not talking about a common area owned by an association. That's private land. We're not talking about the land that Daniel owns right outside this building, that if he allows you to put a sign up, that's his land. That's his private land. We're not talking about any of that. We are talking about public land, public rights of way. That's what we're talking about. So you can't put a open house sign or a listing sign or whatever sign, you can't put that in a public right of way. Okay. Open house signs is a culprit. I mean, y'all put out, I don't know how much, I don't remember the last time I went to a damn open house, but y'all put this stuff out and you put it right at the front of the street in the neighborhood, and there's an open house sign. If that's a public right of way, you have now violated House Bill 3611. That puts this burden on all of us in the industry, and my phone's been blowing up over it, and I wish it wasn't. But people are like, "Can you tell me who owns the strip of land between, this street and this street?" I'm like, "No." Okay. Because I have, yes, I can.
We can look it up.
Yeah, I can figure out who owns the plat. Is it public? And I can figure out if there's a dedicated easement or right of way. But that would take my title examiner a couple hours. So we're not. I always tell people, just don't make it so obvious. Don't put it right out there by a telephone pole or a stoplight. 9 times out of 10, or probably 10 times out of 10, that's a public right of way. If you see a telephone pole or a stoplight, that's usually a public right of way. Okay. Yeah.
So like in any, there's an easement or right of way on any somebody's lot. I mean, out here, if the city would come in, they've got that 3 foot or 4 foot or whatever that is. Is that considered the same? Or?
Yeah. If it's because an easement I guess I should step back. An easement is a grant of right. That's what an easement is. And so if I give a public utility easement to a governmental body, then that easement that strip of land is now owned through an easement grant, but the person that received the easement, the grantee in the easement, the holder of the easement. So yes, to answer your question, if it's given to a public utility, usually power and some sort of utility, yes, that's public, right? But I want to touch real quick on the sort of the practical side and even the law side a little bit. The law requires the city, it's usually a building inspector or a city inspector, right? A code enforcement officer is who is going to enforce this on the municipal level. So a code enforcement officer is going to have to give you written notice and a time to cure. Wait. So the code enforcement officer has to track down who put the open house sign out there. Give them a written notice, not just, hey, what's up? Talk to them. No, a written notice and an opportunity to fix it, an opportunity to cure. And then and only then, if you fail to do it, can you start assessing the $2,500 and the $5,000 fine. Then and only then. So practically, what's the likelihood if your open house sign is up 2 hours or 4 hours or 5 hours that a code enforcement officer is going to find your open house sign out there, track you down, give you written notice, give you time to cure it, you fail to cure it, then they can assess a penalty against you? Probably not likely, right? Now, and this was the last time I spoke about this, somebody said, well, I put up my open house signs overnight, the night before. And I'm like, okay, that's a little bit more time. If I've got it up at 2 o'clock on a Friday afternoon and I'm leaving it up till 6 on Saturday, that's a lot of time for a code enforcement officer to see it and track down who put the open house sign up and give you the written notice. That's a lot of time. So like, the brokerage I was at last week was like, okay, look, we're just going to create a policy that says you can't put your open house sign out until the day of. Yeah, I think that's a good policy. I like that policy. It just reduces the risk. Because if it's out 24 hours, that's a lot of time for someone to figure out. And we're full of we're a society full of narcs. Everybody tattles on everybody, right? I don't know why we've shifted to this in society where everyone's a pansy. It's just that way. Everyone tattles onto everybody. I don't know why, but that's the way it wouldn't surprise me if someone called the city enforcement officer and was the city and was like, Kathy Cap's real estate agent just put an open house sign out on the street corner. I could see another agent doing that. Y'all know how this business is. I love y'all as agents, but it's catty. Okay? It's catty. I could easily see someone tattling on you guys. You guys could. That's why you're laughing, because it's possible, right? So what do you do in the meantime? I certainly don't think you should be putting your open house signs out 48 hours in advance or even 24 hours in advance. Okay? But you do have to know that if the code enforcement officer figures it out, gives you written notice, your first penalty is 1 fine, your second one goes up, and your third one's $5,000. That's a lot of change for an open house sign. Is it worth it or not? I don't know. And they asked me the same question last time. Well, Sean, do you think we can do it? I can't tell you to break the law. Never going to tell you to do that.
So I did some comments on it. And
Yeah.
Well, it's got to have a name on it, tied to it, phone number tied to it. It's just that open house.
Yeah, can they figure it out? I don't know. Maybe. I mean, not thankfully, there's a lot of houses for sale right now.
Yeah.
If there weren't many houses for sale, you could probably, as a code enforcement officer, figure out what neighborhood it was, and probably a lot harder to do now. So I think it's, the law, I understand the intent behind the law, like to clean up the streets. I get that. But like with a lot of laws, it just wasn't well thought out. We gotta figure out how this works in practice.
I'm gonna make a new sign with KW, Cold Banker, Remax.
Yeah.
Like open house, and everybody.
Dude, I love that, man. Let's do it. Yeah. I would absolutely make an open house sign with KW on the bottom and then just direct them to your EXP house. Why not? I like it. Why not? But that is something to be conscious of. I mean, as real estate agents, you have to. And it seems like it feels like the industry as a whole is under attack, and it has been, right? But those of you that are here, you're special. You're here. You're educating yourself. You're going to be the ones that get through all of this stuff, and the other people aren't. So you got to pay attention to these kinds of things. Know these little nuances of the law, what some of these new law changes are. That's going to set you apart from every other real estate agent that's around. Okay. Now let's talk about probably the most important, or the one that impacts you guys most, and the one where people are like, Senate Bill 140. Senate Bill 140, you guys probably don't know the name of the bill, but you do know about telephone solicitation, and that came out. We talked about it earlier. Okay, Senate Bill 140 expands the definition of telephone solicitation to include the little device that half of you are on right now. Okay. So if I'm SMS messaging, if I'm texting, if I'm sending out mass text messages, you now could be considered a telemarketer. Okay. The law, Senate Bill 140, expands it. Previously, it was just phone calls. Now, it's every form of SMS, MMS type messaging. So if you send out and it's not just a time frame. So if I'm a real estate agent and I send out a just listed text, okay, and maybe I send out that text just to other real estate agents, maybe, or open house or whatever. You now are a telemarketer. Why? Because your intent behind sending that message is to what? Solicit business. Right? Why else would you be sending it? You're trying to solicit business. So what does that mean for you guys? That now means, in my humble opinion, every single person that is a real estate agent that is doing any sort of solicitation through any, emails are excluded, by the way, any sort of multimedia messaging, you should be registered as a telemarketer. You should pay the $200 fine. You should get the $10,000 surety bond. You should register with the state of Texas as a telemarketer, and you submit your quarterly reports. That's what's required. And if you don't do that, let me tell you a little bit about the law. Okay. If you don't do that, the recipient of the message has a private right cause of action to sue you. What the hell does that mean? Under the prior version of the law, it had to be a governmental body that came after you to levy a fine. Now, the recipient of the message can sue you personally in a court of law. And if you're not registered as a telemarketer, they're probably going to win 10 times out of 10. Yeah.
Question.
Yeah.
Even they register or not register, do not call us.
None of that. Yeah. The people are like the do not call list. None of that stuff matters. I mean, it matters, but it doesn't matter in the sense of Senate Bill 140. Senate Bill 140 applies no matter what. So like if I'm on the do not call list, the recipient of a message from you is on the do not call list, that doesn't have any bearing on what Senate Bill 140 says. Okay. And here's one step further. If anybody opts in, we call it informed consent to your messaging. You know what? That doesn't absolve you from following the terms of Senate Bill 140. Wait, you mean to tell me, Sean, that somebody could opt in on my website for communications and I still have to register as a telemarketer if I'm soliciting their business? That is exactly what I'm telling you. But what if they were a client of mine? What if we did a closing together 6 months ago? Bingo! I don't know why I did that voice, but you don't have to, it doesn't apply to them. So you could message that person. They were now a client with you, did a transaction with you. They can't come after you as a private right cause of action. So clients can't come after you. Prospects can. Somebody has to have done a deal with you for them to be considered a client. Informed consent, no, that does not make them a client. Registering on your website does not make them a client. You have to have some sort of means with which you can argue they're a client. Listing agreement, buyer's representation agreement. That's a client, right? That is contractually a client. We're not talking about them. They can't sue you if you call them at 5 o'clock on a Saturday to solicit to go look at a house. They can't because they're a client. If you call your best friend from 10 years ago, yeah, that's probably his bestie. Okay.
Santa. It's Santa.
Yeah. If your best friend calls you right now, like if that's his best friend that's in real estate, is calling him right now to solicit his business, but has never done a deal with him, not a client. Your best friend from college 20 years ago that's never done a deal with you, not your client. So my advice to every real estate agent in the state of Texas right now, you heard me say it before, the conservative approach is for every single one of your asses to go register as a telemarketer with the state of Texas. Pay the $200 fine, get the surety bond, and do your quarterly reports. That's my opinion. And it's not enough to me, it's not enough, in my opinion, for your brokerage or your team to register as a whole. That's not enough, in my opinion. The law doesn't carve out, the law doesn't say, well, Keller Williams or EXP, you registered as a brokerage. Now all 2,000 of your agents do not have to register. No, that is not what the law says, in my opinion. I think that's going to get carved out. I think that's going to get flushed out. I think there's going to be lawsuits. In fact, I'll tell you right now, I'll give you some examples. There already are lawsuits. I think there are going to be lawsuits, and I think courts are going to have to clarify and offer some understanding of what this law says. Okay. The private right cause of action. I had a guy the other day I was in another class, I was speaking or whatever, and the guy was like, man, I'm just going to take the risk. And I'm like, let me tell you what the risk looks like. So if you call somebody, or if you message them, and you solicit their business, and they sue you for a private right cause of action, and they can get some idiot judge to buy their damages argument. Maybe they get you for $3,000, $5,000, $15,000. By the way, the law allows you to get treble damages, so that's 3 times the damages. So if the damages were 5, it's now 15, or 2, it's now 6, right? So if they can convince a judge of that, what you thought was going to be $1,000 risk might be a $25,000 pop. You tell me, agent, if you want to take that risk, or you just want to get your shit together and just go register as a telemarketer. For now. And before you ask me, I don't know if that means your phone number is going to show up as spam. I don't know. People ask me that. Well, if I register, is my phone going to be a telemarketer? I don't know. I'm not a tech person. I have no idea. But that wasn't your question, was it?
No. I mean, you forgot my question.
Actually,
No. How about a customer reach out to you first? Because I remember years ago, it's like, hey, Christy, you need a lawyer. I cannot, call you, but you can call me. So is that the same way as?
Somebody reaches out to you, they're still a prospect. Somebody reaches out to you, they're not a client until you ink that contract. So to me, they're still a prospect. I don't care. That to me fits right within the informed consent. It doesn't matter if there's informed consent. I've spent a lot of time drafting informed consent waivers and disclaimers for real estate brokers in the last month. But as I tell every one of them, that ain't going to save you for Senate Bill 140. It doesn't. And everybody's trying to find reasons not to register. I don't get it. Like, just go register. It's not hard. Talk to your real estate broker, or your insurance broker, and figure out who can get you a surety bond. And just go register. And if it ends up being that you don't have to do it because maybe the case law comes out and says there's an exception for real estate agents, or your broker can register for you, cool. But in the meantime, do you want to be the person that gets sued? Let me tell you another quick story. There are going to be people that take advantage of this law, and there already are. I know this investor that, he closes with me, so I can't insult him too much. But he's boasting on Facebook about how much money he's made for in particular roofers that have been coming at him and soliciting. He's settled multiple deals for $2,000, $4,000, $5,000, $7,500. The dude's making a killing. People call him. He then sends a demand letter, and they offer up to settle because they don't want to go to court. It's a brilliant business model. If I had the time, I would do it. No, I wouldn't do that because I don't believe in exploiting laws for one's gain. So I'm totally kidding. I would never do. It's not how I am. But it's how he is, and he's made a lot of money doing it. Before any of your wheels start turning, don't you be one of those people. Okay? But people have been like, oh my God, Sean, geez, I don't want to have to pay to settle. Well, you shouldn't have done it. You should have registered. I don't know what to tell you. You didn't register, and I told you to register, and you got sued. You have the playbook here. Register as a telemarketer, pay the fee, and you cannot get sued for a private right cause of action unless it's outside the time frame. But most of you are probably not calling anybody between 8 and 9 or 9 and 9 or whatever the time frame is. So, I don't want to tell you guys what to do. That's my opinion. I'm always interested to know. I'm not an insurance attorney at all. I don't know what their position is. I think it'd be interesting to know what the insurance brokers and the surety companies are saying, right? Is your surety company or your insurance company, are they saying that they think you can register, as a brokerage as a whole, and that should cover all of you? I don't think it does. That's just my interpretation of the law, though. Yeah.
Is it Form 3401, State of Texas?
I don't know the name of the form. I've never registered as a telemarketer, but I think that might be right. But I don't know that for sure. Honestly, there's a sort of a selfish part here too, that I wish the number of real estate agents would just inundate the state of Texas with these forms. And so the state of Texas then goes, how on earth can we navigate this? We don't have the resources for this. The only way things change are for people to make the change. If you guys just don't do anything, then the law is not going to change. You know, so like, I think it's worth you guys at a minimum research. If part of your business model is solicitation, mass forms of solicitation, I think you should consider it. Daniel, I have one of those little blue light things for gnats in my house. Those things are the best. Those little Zevo things. Oh my God, those are awesome. I don't know what I just saw it over that little blue light right there. So they're amazing. My kids touch it though, which is
Oh, no.
stop
Keep
touching
tapping.
it. No. Do you guys have any questions on Senate Bill 140? And by the way, none of what I tell you today, I want you to scare you with. Like, I mean, I really mean it. I love you guys as an industry. And I really take it very seriously defending you guys. So a lot of the stuff that I give you, it's so that you don't have to call me and go, Sean, I made a boo-boo. Because that's a lot of how the phone calls I get. I'll probably leave here today, probably get 20 to 30 phone calls from real estate agents. Sean, I made a mistake about whatever it may be. And the worst part is when they've like sat through classes with me and they just don't listen. And the cost to fix a mistake is so much more than the cost to just be ahead of it. You know, I don't know if you register, if your name shows up as telemarketing. I have no idea. But those are questions you should be asking. You should be calling your surety company. You should be asking EXP what their position is. Hey, EXP, do you believe that if the brokerage is registered as a telemarketer as a whole, that covers all of our agents? That's what you should be asking them. They're probably going to say no. I know Real Broker says no. I know Real Broker tells every agent they need to go get registered. They should. That's the right thing to do. I know most of the big brokerages are telling people to go register. But ask EXP maybe if they have a bond company or whatever. I don't know. I'm sure Daniel knows companies that do bonds. I'm sure. Daniel knows everybody. Everybody. He does. You guys have any questions about it? Who's going to go look at registering? Again, if it's part of your business. But don't get trapped though. And that bestie from college that hates you now, they could be, it doesn't have to be mass messaging. You can call your best friend legitimately from 20 years ago in college and solicit their real estate business. And if they were mad at you, they could come after you if you're not registered as a telemarketer.
My question is that we've done like mass messaging through a company.
Yeah, that doesn't save you. Doesn't. So then I get that question a lot. Well, we hired a company. Well, doesn't matter. The liability, and the law is clear, the liability is on the person that is sending the message, that's initiated that. So whatever company you use, liability does fall on that company, but it falls on that company and you. So
Gotcha.
now that I think about it, I need to probably register Kathy.
I'm texting all the time.
I know, that's what
They
I
all do
mean.
business with us.
That's
so-
right. See, bingo,
so
client. Don't
they
have to worry
all
about
send
it.
us listings
That's
and
it.
everything.
Yeah, I don't have to worry about it.
I could get my license.
You just say, sue me.
Loan officers are exempt because they're part of a financial institution.
Yeah, there are some exemptions, but you guys are not as real estate agents.
So I'll just get licensed as a loan officer and then I'll just.
No, you just
Just
say,
kidding.
you could just say, sue me.
I don't want to be a loan officer.
And then,
Sue Sean.
yeah, sue me. That'd be fun. I love that.
I always say, do you know who my boss is?
Yeah, there's no, yeah. Nothing tickles my fancy more than lawsuits. So
I don't want to be.
please bring it on. It'll be
Daniel,
fun.
my gosh, no.
I'm sorry, can you repeat? I missed the part of the difference between client and prospect. So I get a lot of referrals and people refer, say, hey, I have this girl who worked with me and she's looking for a house. Can you call her? Can she call
Prospect.
you? So that's not a problem, right?
That's a prospect. That is a problem.
Yeah.
That is a
That
problem.
is absolutely a problem.
So
That
you
is
just
a
need to tell them
prospect.
the
every single time. A client is somebody that you've worked with before, not their friend, not their sister, not their mom. Somebody that's worked with you before, or you have a contractual relationship with now. That is a client. You're talking, that is a textbook example of a prospect.
Okay, so that's a problem. You cannot do
Yeah,
that.
you need to be registered as a telemarketer.
Or
So if your
just-
business is referral based, hey, my sister's brother friend wants you to call her about listing her house. Remember, informed consent doesn't absolve you from Senate Bill 140, and that's prospect.
They can send a joint text message. I'm introducing you to
Still prospect.
Joe.
Still prospect.
True.
If
They
you're
can reach out
soliciting the
to you.
business.
They can reach out to
I mean, now the practical side is like, is that person really going to probably sue you for a private right cause of action? Probably not. But that, one investor I know, don't be that guy that's like, just make an example out of people.
you.
I mean, I'm not kidding. That's a real story. He's made a lot of money. Kudos to him for navigating that.
He's not a lawyer, right? He just knows
No,
law.
he just knows the law. Yeah. No, he's definitely not a lawyer.
So one more question. So I know that somebody said that earlier, but I'm still catching on. So if this person reaches out to me and I talk to them and they said, but before we sign the buyer or listing agreement, whatever, before we sign anything, if we have a couple of conversations back and forth, is that allowed? If
Still
he
prospect.
Okay, it doesn't matter who initiates the conversation.
No. We talked about informed consent. That doesn't change anything. I love Theresa Ma. She's just like trying to find every reason not to have to do this.
I'm not gonna do this.
Yeah. But they reached out to me. They came to my house.
Yeah, what
No,
about
prospect.
this? Yeah.
No, still a prospect.
Yeah.
Piece of candy for 3 cents.
Yeah.
What if we have a barbecue party and people come to barbecue?
That's a perfect example of a prospect.
Oh my goodness.
Why else are you throwing the barbecue? Right? Are you doing it because you really just want to be around the people that are there? Or are you doing it because you want some business out of it? You can't tell me that you throw a barbecue for no business reasons. Well, you might. You're so damn nice. You probably would. But probably would. But no, those are all prospects. It's a textbook example. Yeah, the sign-in sheets, I still am a big fan of sign-in sheets at open houses and things like that. It's the same thing as informed consent. It doesn't save you from Senate Bill 140, but the more things you have, right? The more disclaimers, the more sign-in sheets, the more informed consent. I think it's going to be one of those people that gets sued that then gets a judge to go, listen here, idiot prospect that came after this person. They gave you a disclaimer. You signed in. You had informed consent. Like, this law is getting out of hand. And I think that's what it's going to be. I think it's going to be somebody like that has a sign-in sheet, informed consent disclosures. That person's not going to settle, and I don't want them to. And that person's going to go to war in a lawsuit with the person that's suing them and probably get a judge to eventually go, this is like, we can't have this law. It's being abused. And so I hope that happens.
One more question.
Yeah.
So other than the buyer rep and listing agreement, is there a specific form to use as a form of consent?
I have one that I've written for a lot of brokers that I represent. I used to represent EXP back in the day, but I don't know if EXP has a form. I know Real does. But I would start with your broker first if they have a form like that. Some brokerages do, because I've written it for some.
But there's no
There's no
track
promulgated
or
form, no.
Can they
It's
have
a brokerage
create
form.
a form and have them sign it at closing that allows them to continue to solicit them?
Yeah, I mean, they're still a client, remember?
For the rest
For the rest of
Well-
not just for 2 years.
Yeah, not just for the time frame, which Kathy brought up. Yeah. No, you can't waive your rights under Senate Bill 140, which is a great question, actually. Can you waive your rights under Senate Bill 140? And the answer is no.
So the client list is 2 years?
I think it's 2 years or 18 months. I can't
Or
remember.
yeah.
But it's basically that. I have to look it up again. I can't remember if it's 2 years or 18
What's the
months.
old book?
But it
about
basically,
life?
that relationship extends for that long. So you could solicit them for that long.
Mhm.
I'll go back and
Old
look.
school teaches you a client is a client for life.
That's right.
You're supposed to have a client for life.
Yeah, you just can't solicit them after a certain amount of time.
Well, you can only email them.
But I mean, think about that though,
So-
right? I mean, guys, still be practical. What's the likelihood that a client that loved you is going to do something 5 years when you sold their business? Probably not.
They
much. So be
always do.
practical still. Yeah,
They
don't.
do.
I mean, maybe, yeah. But then-
So when I look at, so upstairs we're cold calling, right? We're cold calling a friend, like I gave Paul a number, he called somebody. That's in violation.
Yeah, for
Unless
sure.
Unless you're telemarketer.
Unless you're registered as a telemarketer.
Correct.
Yeah. Bingo.
So when Jen comes and say, hey, I want to meet this person. Someone's referred.
Yeah.
But if
so-
you're trying to have coffee, I guess
I don't know.
it's-
I mean, use your head, right? Like, I mean, you got to remember, I'm over here talking and spouting about the law, but like, still be practical, still be realistic. You know, what is the likelihood that the person that's invited you to coffee going to go sue you for solicitation? It's probably not very high.
Only if you find that.
But, you know,
million out of one.
correct. Yeah.
that's
But,
the issue.
but think about it. If
So
there's
that's why
any,
I say, go register the $200, go get your shirt.
Yeah, just do it. I don't-
$300, $400.
Just-
covers you.
just do it. I mean, because then it covers you for not only those people that aren't going to sue, but maybe the person you did cold call that is feeling a little litigious.
Another question about the telemarketer.
I thought that was your
thing,
last
so-
question.
Another question, not the last question. I know I
Always
have
have
more.
Always one
I
more,
always
baby.
have more.
Always
Closing-
one more.
closing question.
What's up? Tracy?
So even if when you register as a telemarketer, would that protect you from reaching out people at a barbecue party or
Yeah.
a coffee
Yeah.
meet?
Yes.
Yes,
Yes.
it will.
Yes.
Because
But
you're registered.
you're not technically
But-
telemarketing.
You
You
are.
are.
Your telemarketing, remember, the definition expanded from telemarketing. The definition is so broad now. It's any form of communication for
Telephone.
solicitation. Like if your intent is to solicit the business, if you're calling somebody and saying, or sending them an email that says, come to my barbecue, that's solicitation. It's not telemarketing.
But the emails, for example.
Emails are
Yeah.
fine.
Emails are fine, but text and call.
Are not.
Emails are exempt.
Facebook?
I mean, that's not a multimedia message to that person. I mean,
There's
Now, if you took a messenger and messaged them, that does fit within the definition. If you just post it like Kathy's saying, that's not multimedia messaging. If you just post it on Facebook barbecue, but if you message them, yes, that's solicitation. So you just go register as a telemarketer and then you don't have to ask any of these questions. But you do have to report this is the hard part. This is asinine to me. You have to report all of this stuff to the state once a quarter. All of your sales. Mhm. Any communication.
All communication, every text.
Guys,
message?
now be practical. How are they going to figure it out if you didn't?
Well, we're
Put a
not
couple
against
freaking
the
names
law.
on the list and be done with it. You know what I mean? Like, you don't need to list all. Yeah, you don't need to put all 10,000. Yeah, just you don't put a few names on there. Make them up. I don't care. I mean, well, I do care, but I mean, they're not going to figure that out.
Wow. Okay. Huh?
Yes.
Uncle said I just made 5 phone calls.
Yeah. How are they going to know? How would they really ever know?
Shelly, how do you get to 1,000 agents?
Yeah. I made 5 phone calls and they all worked out.
I just need that 5.
That's it. I just need 5. You guys have any other questions on it? Any legal questions in general?